Welcome to the Deep Dive. We sift through the key info, pull out what really matters, and get it straight to you. Today, we're looking at something absolutely core to open government, getting access to public records.
It sounds simple, right? But making it actually happen often hinges on some really specific legal points.
Exactly. And for those of you who follow open government law closely, you know those details are everything. So today, we're diving into a really important Florida appellate case. Barfield v. Town of Eatonville.
That's 675, so a 10-2223, from the 5th District Court of Appeal back in '96. A significant one.
Yeah, our mission here is to unpack what this case really decided about public records law, especially when it comes to attorney's fees, and why it's still such a big deal for people in this field.
And we're going straight to the source, a court's own opinion. That's our main material for this dive.
Okay, so let's set the stage. Florida has this really strong policy on open government. The legislature laid it out very clearly.
Section 119.01 of the Florida statutes.
Right. It says, quote, "It is the policy of this state that all state, county, and municipal records shall be open for personal inspection by any person."
And just stop there for a second. Any person. All records. State, county, municipal, that's incredibly broad.
It really is. No wiggle room suggested there. It's not like some records or certain people. It's foundational.
Absolutely. And what's fascinating is how that broad statement really sets the expectation. It's the bedrock for transparency, for accountability.
Yeah.
For those of us deep in open government law, this isn't just, aspirational language. It's the mandate.
Yeah.
Public records belong to the public. Full stop.
And the courts have to make sure that happens.
Precisely. That general policy, that spirit, is what the enforcement mechanisms are designed to back up.
Which brings us to the teeth of the law. How do you actually enforce this? Especially when an agency maybe doesn't want to comply?
Well, that's where attorney's fees come in. Section 119.112.
Okay. Lay that out for us, sure.
It basically says if someone has to file a lawsuit to enforce Chapter 119, that's the public records chapter.
Right.
And if the court finds the agency unlawfully refused access to the records.
Unlawfully refused. Key phrase.
Very key. Then the court shall assess and award reasonable costs, including reasonable attorney's fees, against that agency.
And there's mandatory, right? Not may.
Exactly. It's mandatory. If the conditions are met, civil action filed, court finds unlawful refusal, the fees must be awarded. No discretion for the judge on whether to award them, just on the reasonableness of the amount.
So this isn't just about making the person who's sued whole again?
Not entirely, no. The Florida Supreme Court talked about this in the New York Times v. PHH Mental Health Services case.
Okay.
The whole point of this mandatory fee provision is to encourage agencies to comply voluntarily, to follow the law in the first place.
Ah, so it's an incentive for the agency. A stick, maybe?
You could say that. It makes it potentially expensive for them not to comply. It ensures that the state's broad policy of openness actually works in practice day to day.
It gives citizens real leverage.
Absolutely. It provides a powerful recourse. If an agency digs in its heels unlawfully, it knows it might end up paying the citizens' legal bills.
Okay, so we have this mandatory fee provision triggered by an unlawful refusal.
Yeah.
But what exactly is an unlawful refusal? Is it just when they flat out say, no, you can't have these records?
Well, that's where it gets, as you said earlier, really interesting and crucial for anyone dealing with these requests.
Yeah.
Case law has established pretty clearly, you can look at cases like Brenson v. Dade County School Board or News and Sun Sentinel v. Palm Beach County, that it's not just about an outright denial.
Okay, so what else counts?
An unjustified delay. If an agency takes too long without a valid reason to hand over the records, that delay itself can amount to an unlawful refusal under the statute.
Wow. Okay, so dragging your feet is legally the same as saying no in terms of triggering those attorney's fees?
Potentially, yes. If the delay isn't justified, the focus shifts from just the yes or no to the timeliness of the agency's response.
That puts a lot more pressure on the agency then.
It certainly does. It means they can't just, let a request sit on someone's desk indefinitely. They have to act reasonably promptly.
What's reasonably promptly? That sounds like a whole other legal battle.
It can be, absolutely. But the principle is clear. Delay without cause isn't acceptable and can trigger the same consequences as a denial. It forces agencies to be organized and responsive. Bureaucratic inefficiency isn't an excuse.
Right. Which leads us perfectly into the Barfield case itself. Let's get into the specifics there. What happened?
Okay, so the appellant, Mr. Barfield, he requested public records from the town of Eatonville.
Standard stuff so far.
Right, but the town didn't produce them. at least not all of them, and not promptly. So Barfield ended up filing a lawsuit.
Okay, he had to sue to get the records.
Exactly. And here's a really important factual point. A lot of the documents were only handed over after Barfield took further legal steps.
Like what?
He asked the court for a temporary injunction, basically an order demanding the town act immediately, and he got a show cause order issued against the town.
Meaning the town had to go to court and explain why they hadn't complied.
Precisely. So the record started appearing, but only under that direct legal pressure. The lawsuit clearly prompted the production.
Okay, so the town eventually produced the records, but only after being sued and pushed by the court.
Yeah.
Now, what was their defense against paying Barfield's attorney fees? Because based on what we just discussed about delay.
Right, you'd think it was a clear case for fees, but the town had an argument.
What was it?
They argued the delay wasn't really the town's fault, institutionally. They claimed it was because of, and this is their phrasing, either the intentional wrongdoing or ineptitude of its town clerk.
Wait, so they blamed their own employee? They said, don't hold the town responsible, it was just this one person messing up.
That was essentially the argument. They tried to separate the actions of the clerk from the responsibility of the town itself, hoping to avoid the mandatory fee award.
Huh. How did the appellate court react to that defense?
They didn't buy it. Not at all. The court's ruling was really clear on this. They said that attributing the delay to an employee's mistake or even intentional wrongdoing was not a valid reason to deny attorney's fees under the statute.
So the blame the employee defense doesn't work.
Not according to the 5th DCA in Barfield. The court found the town's failure to produce the documents in a timely manner was, plain and simple, not lawful. It was an unlawful refusal, regardless of the internal reason why it happened.
That's a huge point for agency accountability.
Absolutely massive. Think about the implications. It means an agency can't just shrug off its public records duties by saying, oh, sorry, our clerk is incompetent, or someone in records management dropped the ball.
Yeah, the buck stops with the agency.
Exactly. The court made it crystal clear. Internal operational problems, bureaucratic snafus, individual employee errors, none of that absolves the agency of its responsibility under Chapter 119.
And critically, it doesn't prevent the award of attorney's fees.
Correct. The agency is the entity responsible for complying with the law. And if it fails, it bears the consequences, including the mandatory fees. The court explicitly found Barfield was entitled to his fees and costs.
It sends a pretty strong message, doesn't it? Get your house in order.
A very strong message. Internal chaos is not an excuse for violating the public's right to access records.
So what was the final outcome? How did the appellate court wrap it up?
The final judgment was worded as affirmed in part, reversed in part, and remanded.
Okay, let's break that down. What was affirmed, what was reversed?
Well, the part that was reversed was the crucial part regarding fees. The trial court, the lower court, had initially denied Barfield's request for attorney's fees and costs.
Ah, so the appellate court overturned that denial.
Precisely. They reversed that decision. And then the remanded part means they sent the case back down to the trial court.
With instructions.
Yes, with instructions to calculate and award those reasonable attorney's fees and costs to Barfield to make sure he actually got paid.
Got it. What was the affirmed in part about? Was there something else going on?
Yeah, there was a secondary issue. Barfield had also argued on appeal that he'd been wrongly denied discovery, basically, the ability to formally gather more information from the town during the lawsuit.
Okay.
The appellate court looked at that claim and said it had no merit. They pointed out he'd already had a pretty extensive chance to question the town clerk at an earlier hearing, so they upheld the trial court's decision on that specific discovery point.
So that part was affirmed. But the main event, the attorney's fees for the records delay, was a clear win for Barfield on appeal.
Absolutely. The core issue, the enforcement of the Public Records Act via attorney's fees, was decided firmly in his favor.
So let's pull back. What's the big takeaway here for, the people listening who work with or litigate under Florida's open government laws?
Well, Barfield really solidifies a couple of critical points. First, it powerfully reaffirms that the attorney's fee provision in 119.9 is mandatory when there's an unlawful refusal.
Including unjustified delay.
Critically including unjustified delay. That's number one. Number two, and maybe even more impactful in practice, is that it shuts down the internal problems excuse.
Right. The agency can't hide behind employee mistakes or internal disorganization.
Exactly. The responsibility lies squarely with the agency as an entity. If they fail to provide timely access unlawfully, they are on the hook for the fees regardless of the internal reason. It reinforces that the judiciary takes the state's open records policy very seriously and will enforce the mechanisms designed to make it effective.
It really underlines that the cost of noncompliance falls on the agency, pushing them towards getting it right.
That's the intent, and that's what Barfield reinforces.
So just to recap the core lesson from Barfield, timely compliance with public records requests isn't just good practice, it's legally mandated. Unjustified delay is treated like an unlawful refusal. And if that happens, the agency will likely have to pay the requester's attorney fees. Pointing fingers internally won't get them off the hook.
That sums it up perfectly. The consequences are clear, and the responsibility rests with the agency.
Which leaves us with something to think about.
Always does.
How does this kind of ruling, a strong stance on agency accountability, especially saying internal issues aren't an excuse, how might that actually change things on the ground?
You mean inside the agencies themselves?
Yeah. Does it influence how they train their staff, how they set up their procedures for handling requests, maybe even who they hire to manage records?
That's a fascinating question. You'd hope it would lead to, better training, more robust systems, a clearer understanding internally that this isn't optional, that compliance is part of the job description at every level.
And what does a case like Barfield tell us about the power of using the legal system here?
Well, it shows that legal recourse isn't just about getting compensation after the fact. It can be a powerful tool to actively uphold the public's right to know, to force compliance, and to shape agency behavior moving forward. It demonstrates the judiciary's role in making sure that right is real, not just theoretical.